At this time, Donna Ayers wishes to withdraw her objections against Curtis McCall, Richard Duncan, Audrey Baker, Gloria Ware, and Jeffrey Radford.
Just to make sure I've got the records right, that's Audrey Baker, Rich Duncan, Curtis McCall, and would you go on?
Gloria Ware.
Gloria Ware.
Jeffrey Kent Radford. Those are associated with the McCall team.
Okay. All right. Thank you, sir. Got all those?
Okay. Mr. Chairman, I think we only have two remaining matters, Radford versus Jennings and Baker versus Hill. It's an open meeting, but those are the only two things remaining. You can feel free to stay and watch if you want, but that's all we got left at this point.
Oh, are you on those two? Okay. Who's first?
I believe on the agenda,
Radford
versus Jennings.
Okay. Just hang out and injury my appearance to Mr. Radford.
The records show that in the case of Radford versus Jennings, that Mr. Kelly has filed from the firm of Foley Kelly, entered an appearance for Jeffrey Radford Sr.
If the board would take notice of the verified objector's petition and also the nomination papers of the respondent. Then just to move to argument, basically it's undisputed that neither the respondent candidate's statement of candidacy nor her petition sheets, or his petition sheets, sorry, state that what district he's running for trustee in. So if you look at Mr. Jennings' statement of candidacy, he lists office village trustee but doesn't state what district. And it's also the same for his petition sheets in the office. He says village trustee of Cahokia but does not list what district. So basically, without designating the trustee district, it's a violation of section 10.5 of the Illinois Election Code. And it's also a violation of section 10.4. And we stand that that's confusing to voters. They don't know which district he's going to be in. That's our objection.
The response I have is that he has substantially complied. He has provided his actual address. His address indicates that the district, he lives in the district that he's running for. Under the line of cases which this board has earlier cited, in particular, Jackson Hicks versus East St. Louis Board of Election Commissioners, which was decided in this county with only in the last cycle, which this board is well aware of. There is a very strong movement towards substantial compliance, and I argue before this board that Mr. Jennings has substantially complied with the obligations.
Does either side have any case law in support?
I do. Board, I actually have three cases. Salgado v. Marquez, which is a 2nd District 2005. Hebler v. Municipal Officers Electoral Board, which is 2nd District 2003. And then also Zapolsky versus Cook County Officers Electoral Board, which is 1st District 1998. I only have one copy of each, but I can get a copy to Mr. Evans if I can just get in the back and make copies.
And none of those cases are cited are from the 5th Appellate District. And Jackson Hicks.
You have a copy of that case?
I just had one, but I can give it to you.
I'll just borrow it.
Sure. It is highlighted. I apologize.
All right. That'll help me catch the chase. Was either
I do have
party
multiple
disputing
copies.
any of the facts asserted by either side?
No, I'm not.
Does the objector have any questions for the respondent, who is present?
No, but I would just like to comment, there's also, and I don't have copies of them, there's cases out of Chicago where failure to identify your ward doomed candidacies as well. So, I mean, I have those cases, I can get you those sites if you'd want them. One is Haley v. Miles, Chicago Electoral Board 2011, Taylor Jr. v. Harley, that was Chicago Electoral Board 2007. And these all came out of an icicle with regards to election law.
But I would note that electoral board decisions have no precedential value and at most are persuasive. Again, this is all Chicago law that's being cited.
So, of the cases submitted to us by the objector, the essence of it, well, these are cases from a different appellate district.
I'm sorry?
While these are cases from a different, appellate district, I'll sit up and not mumble. They all are based upon Supreme Court decisions, which ultimately we are bound by in this district. And the essence of those being the facts that alleged in the cases that we've been submitted, that the specific office being sought was not listed, and the reasons why they sustained the objection and removed the person from the ballot were essentially some of the things that we discussed in the previous cases that were before us here this morning. Confusion by the voter and confusion by the authority that has to decide how you put something on the ballot and who is voting for what. I don't have any reason to believe that Mr. Is it Hill?
Jennings.
Excuse me, Mr. Jennings, excuse me, had any intention to try to confuse the voters. But they did sign something that does not say what it is that he's running for. And if this were to be upheld, what does the clerk do? How do they put it on the ballot? What are they supposed to do in terms of putting it on the ballot? So that's the essence of those. Now, another case that you provided me, Mr. Evans, is about the number of signatures. Again, that was a case I referenced previously. It was a case involving Mayor Parks, the previous mayor of East St. Louis, not having enough signatures. Now, that's not an issue here today, so I'm guessing the relevance of that case you gave me is just to raise the issue of substantial compliance.
Yes.
Okay. Does either party, first the objector, have anything in response to the questions I'm positing to you?
No, I mean, I think you hit the nail on the head. It's an issue of confusion, and I mean, you have to specifically designate what office you're running for. He's running for trustee of district, it's, I believe, 1, right? 5. So you need to put District 5. I mean, if you just put trustee, I'm gonna sit up here and just guess numbers, like I just did.
How do we know what district he's running for?
We didn't.
Does the respondent have any response to that?
It would be based upon his address.
Well, I know that you mentioned that precedent is important. Having sat on these boards for 10 years now, first as a circuit clerk and then as a state's attorney, on almost every case that I can recall when someone didn't put the specific area that they were running, we sustained the objection. And I don't have any reason to believe that that law has changed. So I would vote to sustain the objection.
Second.
Motion by Mr. Kelly to sustain the objection. Seconded by Mrs. Clay. Roll call, Ms. Clay.
Aye.
Mr. Kelly.
Aye.
Chair votes aye.
May we keep these cases for the record?
Yes.
You have a right to appeal our decision.
Mr. Jennings, you can appeal our decision. So I want you to know you can do that.
Okay. The next case that we'll be handling will be Baker versus Hill. And in that case, we have Mr. Evans, who will be representing Baker, and Mr. Kelly with Foley Kelly will be representing Baker.
Thank you, Chairman. I just want to say that I'm not proceeding on any sort of signature challenges to Ms. Hill. I'm only proceeding on the same basis that we argued on Mr. Jennings. If the board takes notice of the verified objector's petition along with the nomination papers, again in violation of sections 10.4 and 10.5 of the election code, Ms. Hill, in her statement of candidacy and also in her petitions, does not list what district she's running for as for trustee. Same thing with Mr. Jennings. It's confusing to the voter, confusing to the county who has to record who is running for what. And for the same reasons why it has to be specified in the law, we object. And this would be trustee of District 1 that she was running for.
And on behalf of Ms. Hill, who's not here today, I'll just stand in the prior argument.
In the event there's an appeal on either one, if you could articulate that argument again for us.
Certainly that Ms. Hill has properly identified her address. I argue that she has substantially complied with all the requirements of the election code to run as a trustee for the village of Cahokia, and that her address is properly noted on both her nomination sheets and her statement of candidacy, and from that you can discern her address and therefore which trustee position she's running for.
Do copies of the original petitions in this case? I don't seem to have a copy. I'm sorry.
And can we look and see on the original, if on sheet 1, if the person's address is listed on the...
Is that in there?
should choose the one that I think that's what all the next one.
Not just like the actual well, not but the other one does.
Yeah.
If the petition does not show our address in all documents, then I withdraw that statement.
Mr. Jennings, too.
Jennings.
Just want to make sure I didn't miss something. Do you want for the record to cite the cases again that both of you are submitting? Do you want for the record again to cite the cases that both of you?
I relied upon the case of Jackson Hicks versus East St. Louis Board of Election for the proposition that the courts are moving strongly to substantial compliance.
And I submitted it to the board Salgado v. Marquez, 2nd District 2005, Hebler v. Municipal Officers Electoral Board of the Village of Lakemore, 2nd District 2003, and Zapolsky v. Cook County Officers Electoral Board, 1st District 1998.
Thank you. Got all that?
I can give you the spellings to... Oh, you don't know how to spell Zapolsky?
Did either of you, both of you had a chance to articulate your arguments for this
Yes.
particular case?
Yes.
As in the previous case, and I wanted to look at the originals again. Yeah, I did see that. See, as with the previous case involving Elmer Jennings, I know that Mr. Evans, you've argued substantial compliance. Mr. Kelly, you've argued and submitted cases which are, while they're from other appellate districts, they do within those cases cite Supreme Court decisions. And obviously it's been my experience on this board and our previous rulings that if the specific office is not listed on the petitions, that the objector's objection is sustained. I would just point out in this case that neither on the statement of candidacy or even on the petitions where they're collecting signatures, neither one of those does it actually say. So I think that reiterates the confusion that would be created. I don't think, again, or is it Mr. Hill or Ms. Hill?
Ms. Hill.
Ms. Hill was trying to confuse anyone or doing anything nefarious or inappropriate. But I'm not sure how the clerk is supposed to decide where to put this person on the ballot. And I think that creates confusion from a ministerial function standpoint. I don't think I'd be hard pressed to say that the respondent was trying to confuse anybody. But there is no statement anywhere that I can find here that says which office she's actually running for. So, for the same reasons as the previous case, I would make a motion to sustain the objection in this case.
Motion made, or second?
Second.
Second by Ms. Kelly. Roll call. Ms. Kelly?
Aye.
Mr. Kelly?
Aye.
Chair votes aye also. The objection is sustained. You have a right to appeal any of our decisions to the courts.
These are not disputed facts, these are matters of law, and you know, the law changes, and the court might agree with us, or they might disagree.
I believe that wraps up what we're going to be doing today. We'll plan on reconvening this hearing on the 17th at 10 o'clock. Location to be announced, what I can do for room reserve. Ready to adjourn?
Make a motion to adjourn.
Motion to adjourn.
Second.